those that would be listening and watching across all corners of the country. My name is Mkhwebane Richard Ganji. I'm the chairperson of this committee. Just to recognize myself, to make a few remarks as I welcome before we proceed. I think at this point, it's important to say that because this is a committee that will be here now after all the fires that were here physically for the first time, to remind ourselves of the things that we have said since our establishment and when we restarted in February 2022, that what we have is a constitutional process of the National Assembly. This is a process that we do with no predetermined outcomes. I've always made the point that none of us must have any briefcase outcomes. You might be carrying your briefcase. If you have determined a particular outcome for this process, we do have a medical team here that is going to attend to your stress levels, because it's going to be a very rigorous process. We might not come to your outcome at the end of it. Our guiding compass is fairness and rationality of this process. And we would have said before, and I want to repeat, that we're only going to be influenced by evidence and facts in front of us and the rigorous scrutiny of that evidence and facts. Nothing else. It's an exercise on accountability. Today, we meet not as a start of a process. We're marking the next phase of a roadmap that would have developed in February 2022. A roadmap that said that's when we started, and that the hearings. And I thought it's important to mention and emphasize that point because what we're doing is an exercise to examine the fitness to hold office of the public protector. And therefore we get into this with a twofold possibilities. We get into this determined to hear evidence and witnesses that are going to place in front of us evidence that will assist in exonerating the public protector, as well as evidence and facts that will indicate to us and help us have adverse findings. So in both ways, we're asking for, throughout the process, objectivity of this. In our last meeting, I asked for the draft directives to be prepared to govern the appearance of persons before the committee. Thankfully, this has been done. And I understand the public protector legal team wishes to address me on some of the aspects of these directives before issuing them. I will give an opportunity and afford the legal team of the public protector to address us on that at some point in a few minutes' time. But before I proceed to the next item, I'm just going to ask Thembi Nkosi to indicate if we have received any apologies first.
Thank you, Chairperson. As it stands, we have one apology from Ms. Dlakude. She's seeing a doctor today and will be joining us from tomorrow. Thank you, Chair.
Thank you. I was told earlier that Ms. Lottrit has just landed, will be on his way, will be joining us. I want to record that. Those are the only apologies we have. Honorable Mkhwebane.
Thanks very much, Chair. Greetings to you and greetings to colleagues. There has been an indication from Mr. Siabi, Honorable Siabi, to your staff, so he says, that upon arrival at the airport, he lost his wallet, which means IDs and so forth, so he could not get into the plane. He will join the sitting tomorrow. Thank you.
Thank you. I'm told that he found his way onto the platform. He is here virtually. That's the beauty of this hybrid. Thank you, Honorable Mkhwebane. With that, I want to proceed to the next item. And I'm going to take this opportunity and recognize and invite the evidence leader, Advocate Nazarene Bauer, to make her opening remarks, as well as touching on the directives. Honorable Bauer, you are recognized. Advocate Bauer, you are all recognized. I'm now trying to make you an MP. I hope you're not going there.
I'm not sure if that's a promotion or demotion. But
certainly a promotion. Go ahead, Advocate Bauer.
Good
Thank
morning.
you.
Good morning, Honorable Chairperson, Honorable members of the committee, Advocate Mkhwebane, and to our colleagues. This committee sits as the first of its kind in South Africa. And so in that sense, it is sailing in uncharted waters. And even though this is a maiden journey, it is not without beacons, the odd lighthouse, frequent buoys to guide its route. It is also not without a map and a navigation system with which to steer its course. Given that this is the first impeachment process, it is important for us to all have a common understanding up front as to what this committee is and what it is not. It is not a court of law. It is not a quasi-judicial process or an adversarial process. You do not sit as a committee of judges. In regard to the issues with which this committee is seized, it is bound by the judgments handed down by courts of law and which are before this committee, as is anyone else, and it has neither the power nor is tasked with rewriting those judgments. It is also not tasked to assess a criminal conviction.
Recording in progress.
And these are not criminal proceedings. There is no accused, and there's no one that has to plead guilt or innocence. The committee does not have final decision-making powers. That power rests with the National Assembly that adopted rules to create this committee precisely to deal with the process of the removal of office of, amongst others, the public protector by providing a procedure for consideration of such removal. A procedure which takes cognizance of the fact that it should not be an easy feat to remove a public protector. In addition, these procedures confer on the public protector important procedural rights and define the limits of the committee's powers and functions within the Constitution and the rules of the National Assembly. The committee is tasked to consider the motion tabled on 21 February 2020, more than 2 years ago, by the Chief Whip of the Democratic Alliance, Ms. Mazzoni, and we shall refer to it as the motion. It initiates this inquiry for the removal of the public protector on grounds of alleged incompetence and or misconduct. We will in the course of this address elaborate further on the motion itself. But in doing so, the committee has to apply itself to the documentary and oral information placed before it with an open mind. open to all possibilities on the information provided. In this exercise, the committee is not circumscribed by the reasons, recommendations, or any conclusions drawn in the report of the independent panel. The inquiry that is before this committee is but one leg of a journey to the inquiry's final destination, the National Assembly. And en route, the process encounters various ports into which it has had to dock or forced to anchor. But we reiterate, the committee is not the ultimate decision maker. When it reaches the National Assembly, the committee performs a reporting function, making recommendations to the National Assembly, which in turn is empowered to make the decision to remove a public protector from office in discharging its constitutional obligations. And this must encompass a process carried out with integrity and fairness, not only because the rules call for the conduct of the inquiry to take place in a reasonable and procedurally fair manner, but also because the office of the public protector is one of fundamental constitutional significance that demands that the incumbent be treated in such a manner. And when we say reasonable and fair, when we refer to the reasonableness and fairness of this process, in our view, it is not only to the public protector, but to all participants who make themselves available in this inquiry. It must be fairness to witnesses who participate to ensure that their voices are heard and that they too are treated with dignity and respect. Also, to stay on course, this committee has determined terms of reference which permitted the appointment of myself and my colleague, Advocate Nomisa Mayosi. Both of us are practicing advocates, and we have both had experience in relation to commissions of inquiry. I led the evidence in the Kalicha Commission of Inquiry investigating allegations of police inefficiency in Kalicha and a breakdown in the relations between the community and police. Advocate Mayosi played an integral role representing the complainant community of Kalicha in that inquiry. In addition, I led the evidence in a further inquiry in terms of Section 12(6) of the National Prosecuting Act. We both have extensive experience in a wide range of legal matters. I raise this to make the point that notwithstanding our previous experiences, this inquiry remains a novel task for us as practicing advocates and as appointed evidence leaders. And it's not only a novel task for us, it's a novel task for this committee and for the National Assembly. And what must be understood is what we are sure is that we as the evidence leaders are not prosecutors tasked to determine guilt or innocence. We do not represent a client. We do not have a burden of proof to discharge or a case that must be met by a client. The inquiry is of an inquisitorial nature, informed by Parliament's constitutional oversight mandate and the principle of fairness. Our primary role as evidence leaders is to present evidence, whether it is of an exculpatory nature or implicating nature. And during the course of these proceedings, you are likely to hear both. In our engagements with persons, both of those who are willing to assist and make themselves available to give evidence, and those adamantly opposed to being part of this process, we endeavored to clarify that we're neutral, that the purpose of our engagement was to seek information to place before the committee, which could turn out to be, as I've pointed out, either exculpatory or confirming of the motion. And we will endeavor to do both. Fairness demands that this committee view the information and evidence placed before it through the same prism of neutrality in order to permit a fair, open, and unbiased assessment of the merits of the allegations made in the motion. As a precursor to this committee, the former Speaker of the National Assembly established an independent panel to conduct a preliminary inquiry of the motion. This panel was tasked solely to determine whether there is prima facie evidence to show that the holder of public office committed misconduct, is incapacitated, or is incompetent. The role of the panel was limited to a desktop exercise of an assessment of the relevant and recorded information placed before it by members or by the holder of a public office in terms of this rule. It did not go outside that ambit. The panel described its functions as follows: applying the Constitution, the law, and the National Assembly rules impartially and without fear, favor, or prejudice. On the evidence made available to conduct and finalize a preliminary assessment relating to the motion proposing a Section 194 inquiry. To determine whether there is prima facie evidence showing that the public protector has committed the misconduct or is incompetent. To exercise its discretion in deciding whether to afford any member an opportunity to place written or recorded information before it within a specified time frame. To provide the public protector with copies of all information available to it relating to the assessment. To provide the public protector with a reasonable opportunity to respond in writing to all relevant allegations against her. Not to hear oral evidence, and to make recommendations in its report, including reasons for those recommendations. The panel submitted its report on 24 February 2021 and recommended, for reasons contained in the report, that the charges as set out in the motion of incompetence and misconduct be referred to a committee of the National Assembly. Let us be clear that the use of the word charge is not to be understood in a criminal context. Rather, the term charge is to be understood as the grounds for averring the removal from office of the holder of a public office. The report served before the National Assembly on 16 March 2021, and it resolved to proceed with the Section 194 inquiry establishing this committee. Now, turning to the committee, we emphasize that whilst the committee has no inherent jurisdiction, it also has all the powers applicable to parliamentary committees as provided for in the Constitution, the applicable law and rules which it exercises, subject only to the Constitution, the law and those rules. The rules governing the process has already passed constitutional muster. That ship has sailed. The functions and powers as set out therein include that the committee must conduct an inquiry and establish the veracity of the charges in the motion and report to the Assembly thereon. In the absence of any lawful impediment, this committee is enjoined to exercise its powers and perform its functions and give effect to its obligations. It must do so based on information before it, within a reasonable time frame, without undue delay, and in a procedurally fair manner. The Constitutional Court has confirmed that the public protector has the right to be heard in her defense and to be assisted by legal practitioners or other experts of her choice. The latter may on her behalf participate, including making opening and closing statements and cross-examining witnesses, as well as making written submissions on the findings and recommendations of the committee, in line with the audi alteram partem principle of natural justice, prior to the report of the committee being adopted and tabled, and which representations must be considered by the committee prior to the adoption of the report. To perform its task, the committee established terms of reference, encapsulating its task as one of assessing the charges contained in the motion and reporting to the National Assembly of its findings and recommendations. And like the panel, I reiterate, and we reiterate, that the committee must perform its tasks with a state of mind that must be neither unduly suspicious nor unduly believing, but one that simply ascertains whether the information at its disposal is out of place or fits with the parameters of the motion. Pursuant to an obligatory parliamentary process, written comments were elicited from members of the public. Whilst all these statements serve before the committee to be considered in its deliberations in the context of the motion, only some of those persons who have sought to assist the committee in its work will be called to provide oral evidence. Members of the public who made written submissions are thanked for their assistance and contribution. The process to be followed is open and transparent, as evidence leaders over and above those who have made, as evidence is led over and above those who have made public submissions. We will call these various witnesses to provide evidence and put written evidence before the committee. In addition, the findings of judgments of various courts, the High Court, the Supreme Court, and the Constitutional Court, by which this committee and all others are bound, will be drawn to the attention of the committee. It bears noting that this exercise is not a comparative exercise. The current public protector was perfectly entitled when stepping into the position in October 2016 to determine how she intended to perform her functions and exercise her powers. whether or not she did so in the same manner, in a similar manner, or in a different manner to her predecessors is of little import to this inquiry. Section 194 of the Constitution sets out the circumstances in which a public protector may be removed from office. In essence, grounds of misconduct, incapacity, or incompetence. It requires that there must be a finding to this effect by a committee of the National Assembly before the National Assembly may adopt a resolution calling for the removal of the incumbent. So the starting point of such an evaluation, in our view, must be the nature and requirements of the office of the public protector. It serves little purpose to the work of this committee, faced with the complaints, to use as a measure of competence and good conduct performance of predecessors. But we will not in this opening address be setting out the constitutional and legislative framework for the public protector, as this task will be performed by our first witness, Hassan Ibrahim, who has kindly agreed to assist the committee in respect hereof. Unlike other witnesses, Mr. Ibrahim will not be dealing with any of the specific charges as set out in the motion, but will instead traverse the legal foundations underscoring what was created in South Africa and is known as the public protector. So we limit our opening address in this regard to simply drawing the committee's attention to the following. South Africa established the public protector as one of the bastions to fight against corruption, unlawful enrichment, prejudice, impropriety in state affairs, and for the betterment of good governance. It is imperative for the South African public at large to have faith in the integrity of the office and its incumbent in order to have faith, trust, and give effect to the work rendered by the public protector. In order to do so, and we next turn to consider two further factors, courts and judgments, and the motion. With reference to the court judgments to be considered during these proceedings, many of the reports that are the subject matter of this inquiry were considered by different courts. As such, it is informative to briefly consider the hierarchy of courts in our country and the binding nature of precedent on lower courts. I venture to repeat what is set out in the Constitution, that the judicial authority of the Republic vests in the courts, which are independent, subject only to the Constitution and the law, and which must apply impartially, and which must apply law impartially and without fear, favor, or prejudice. Their function should not be interfered with, and other organs of state, through legislative and other measures, must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. Most important is that an order or decision issued by a court binds all persons and organs of state to whom it applies. There is also a hierarchy of courts. The decisions of the Constitutional Court are binding on the Supreme Court of Appeal. In turn, the Supreme Court of Appeal and the Constitutional Court are similarly binding on lesser courts, and the decision of the High Court are binding on Magistrates' Court within the areas. Final judgments in the event of appeals are those of the Constitutional Court or the Supreme Court of Appeal, and the divisions of High Courts where there is no longer a possibility of an appeal and where no appeal has been pursued. These are binding. In the main, a number of issues raised before this committee relate to several cases which the courts have already considered and pronounced on. These will, amongst others, be referred to as the hearings proceed and include the judgments relating to the South African Reserve Bank or the Absa Lifeboat Report or the CX Report, the judgment relating to the Vrede Dairy Project, the judgment relating to the Financial Sector Conduct Authority, the judgment in the dispute in respect of Ms. Pasani Baloy, the judgment relating to the CR17 campaign, the judgment in relation to the investigations conducted of Minister Gordam and in which Mr. Pillay and Mr. van Logrenberg prominently feature. Both of the latter have made themselves available to provide evidence to this committee. The judgment in relation to the Commission of the South African Revenue Services pertaining to confidential taxpayer information and the public protector's subpoena powers, and the matter involving the government employees' medical scheme. The legal principle of stare decisis is a juridical command to the courts to respect decisions already made in a given area of law. The practical application of the principle means the courts are bound by the previous judicial decisions, as well as the decisions of courts superior to them. The adherence to the principle by our courts permits certainty, predictability, reliability, equality, uniformity, convenience. It is not simply a matter of respect for courts of high authority, but the manifestation of the rule of law itself. And this we all know is one of the founding values of the Constitution. Where the courts have reviewed and set aside those reports of the public protector, they no longer have any legal efficacy. It is not for this committee to second guess the decisions of the courts and what is already established law in the country. They form part of the evidence presented in support of the allegations made in the motion. So, for example, the CX report, the initial Predetermined report, the reports in relation to the investigations into Minister Gordhan and which will form the evidence, or which will be referred to in the evidence of Mr. Pillay and Mr. van Lochenberg, these have already been finally reviewed and set aside and have no legal efficacy. And of relevance is what the courts found in those cases in relation to the conduct of the public protector. This procedure commonly underlies all the judgments involving the public protector. Whilst we will refer this committee to the dicta or in ordinary parlance, the pronouncements of a number of judgments during the course of these proceedings, it must be borne in mind that this takes place in the context of either reviews, interdicts, or appeal proceedings, most of which in some way or another relate to a report that's been issued directly or indirectly. Indirectly, we mean that while the litigation may have commenced with a review of a report or to stop a remedial action from being enforced, by the time it reaches the appeal stage, all that may well have been left is the question of costs. In the normal course of events, in applications to court, the case is brought with a litigant relying on a founding affidavit. A respondent has an opportunity to file answering affidavits to deal with all the allegations set out therein. There is also an opportunity to file replying affidavits, which affords the applicant an opportunity to respond further to allegations in the answering papers. In some cases, a party may simply file an explanatory affidavit to assist the court. If the allegations in the founding affidavit filed by an applicant are not dealt with in the answering papers, then the applicant's version stands undisputed. Where the respondent in the judgments before this committee substantively answers and denies the allegations made in a founding affidavit, the applicant has the opportunity to deal with those and deny it in a replying affidavit. The respondent's response, where one is given, will prevail, and where it results in a bona fide dispute of fact, the litigant must refer it to oral evidence. This is what lawyers call the tried and tested Pascon-Evans rule, explained simply. This is how the courts deal with evidence in application proceedings. So in the main, the judgments on which the motion relies emerges from affidavits already filed in which certain allegations were made and responded to under oath, and a court has pronounced on it. It is not this committee's function to revisit those or to second guess the judicial process. A second category of cases relate to labor matters arising in the context of persons who had or remain in the employ of the Office of the Public Protector, and they will come and apprise the committee of their experiences. It is useful to consider the test applied by the courts when evaluation of such reports take place. The courts have stated the aim of the evaluation of the relationship is not to determine whether some means will achieve the purpose better than others, but only whether the means employed are rationally related to the purpose for which the power was conferred. A rationality review also covers the process by which the decision is made. So both the process by which the decision is made and the decision itself must be rational. If a failure to take into account relevant material is inconsistent with the purpose for which the power was conferred, there can be no rational relationship between the means employed and the purpose. So it is not the task of this committee to determine whether the reports were factually correct or not, but it is about how the reports were arrived at and whether these reports were prepared without fear, favor, and without no real or apparent bias, reflective of the correct law and in accordance with the prescripts of the Constitution, the Public Protector Act, and other relevant laws, including the common law. And it is this context in which a determination must be made as to whether it gives rise to misconduct and or incompetence. We do not at this juncture seek to set out the context of each and every report, but as the subject matter is introduced by a witness during the course of such evidence, we will endeavor to draw the relevant portions of the judgments to the committee's attention. We do so in that under scrutiny in the motion in the context of the reports of the Public Protector that have been reviewed and set aside is the manner, the process, the steps taken in the context of the compilation of these reports. And now if one turns to the motion itself, there are 4 composite charges set out in brief. The first is that the Public Protector is guilty of misconduct in an investigation and report into allegations of failure by the South African government to implement the CX report and to recover public funds from Absa Bank. For ease of reference, we will refer to it as the CX matter. The allegations relate to the dismissive, high-handed, biased, well, I'm going to say, quote, let me repeat this. The allegations relate to the, quote, dismissive, high-handed, biased, and procedurally irrational and unfair process, unquote, in the conduct of the investigation, including that she met with the presidency and the state security agency secretly, that she broadened the scope of the investigation without notice and explanation, that she altered the remedial action on the instruction and or advice of the presidency and or the state security agency, that she failed to give affected persons notice and opportunity to comment on the proposed remedial action,
Can somebody in the virtual platform just indicate if you are back? Can you hear me?
Audible, Chair.
Yes, Chair.
Yes,
Yes,
Chairperson. Audible, thank you.
Audible, Chair.
We can hear.
Shaky, ma'am.
Yes, thank you, Chairperson. We're back. Thank you.
We can't hear you.
I can hear you loud and clear, Chairperson.
Yeah, you've got to speak up. We can hear you. Can you hear us now?
Very clear,
Yes,
Chairperson.
Okay, very clear. Okay, thank you. We'll fix their voice coming in because we can't hear. We'll have to attend to that, but he indicates that they can hear us clearly. Thank you. We will proceed. Advocate Bauer, my apologies for stopping it there. It's in the interest of everybody else following the process. Please go ahead.
Let me repeat the sentence.
Yes.
The motion sets out allegations in full, and I do not repeat them in full. But what is alleged is that the public protector had grossly overreached and exceeded the bounds of authority, had demonstrated a failure to appreciate a legal duty to come to the aid of the vulnerable and marginalized members of society, and demonstrated legal ineptitude in her ability to comprehend and accept the appropriateness of proposed remedial actions. In respect of the report on the Financial Services Board, conceded that irrationality, forensic weakness and misunderstanding and/or misapplication of legal principles is demonstrated in such report, and demonstrated the failure to appreciate the public protector's heightened duty towards the court as a public litigant. That she demonstrated irrationality, forensic weakness, incoherence, confusion and misunderstanding of the applicable contractual, constitutional, administrative law principles. That she does not understand a constitutional duty to be impartial and to perform her functions without fear, favor, or prejudice. The final charge is also one of misconduct/incompetence, in that the public protector is accused of having intimidated, harassed, and or victimized staff. Alternatively, has failed to protect staff in the office of the public protector from intimidation, harassment, and or victimization by the erstwhile Chief Executive Officer in the office of the public protector, and has committed misconduct by and or demonstrated incompetence in the performance of her duties in failing to manage internal capacity and resources, including staff, failing to prevent fruitless and wasteful and or unauthorized expenditure and legal costs, failing to conduct the investigations and or make her decisions in a manner that ensures the independent and impartial conduct of investigations, and to avoid making findings against certain public officials while deliberately seeking to reach conclusions of unlawful conduct and impose far-reaching remedial measures in respect of other officials without basis. These are the contents of the motion which serve before this committee. Now, we have earmarked several witnesses. However, at this juncture, it is not anticipated that all the witnesses will be called to provide oral evidence. In fact, there may well be an agreement with the legal representatives of the public protector that some evidence based solely on affidavit will be accepted. And in other instances, it may well not be necessary for such oral evidence to be placed before this committee at all. As we at the outset of this address pointed out, this is a distinctly novel process. It is at the best of times intimidating for any witness to appear before one judge. It is seldom so that the witness gives evidence before a full bench of 3 judges, and it must be appreciated that in the context of this inquiry, there is a committee of numerous eminent members of parliament, not to mention my colleagues who also act in this matter. It is no easy feat for any witness to appear before this committee. It takes considerable courage for them to be prepared to do so. Given the nature of this process, it must be appreciated that the witnesses who do come forward to give evidence of whatsoever nature are ordinary people who have been requested to assist this committee or may well have been subpoenaed to do so. But in doing so, A number have also indicated that they regard it as their responsibility, if asked, to appear before this committee, even though they may not wish to do so, and provide their insights. And we as evidence leaders ask this committee to treat them respectfully and allow them to leave this process and this committee with dignity. As fundamental as it is to this process to respect the public protector, if and when she elects to give evidence, that she be treated with dignity and respect, so too must be the case with the witnesses. We have encountered a significant level of concern, fear, and even cynicism of this process in our engagements. Cognizance should be taken thereof, and efforts must be made that there's no credence be given to those concerns. We reiterate, to appear in this forum is daunting in itself, and questions should be relevant to the motion and on hand, asked respectfully and with adherence to the basic values entrenched in our Constitution. To do otherwise would undermine the integrity of this process in its entirety. We thank you.
Thank you, Advocate Bauer, for those opening remarks. At this point, members and colleagues, I will now recognize Advocate Dalimbofu to make his opening remarks and respond. Maybe before that, I just see a hand, Honorable Olomisa.
Thank you, Chairperson, colleagues, Public Protector. The evidence leader, I didn't hear her telling us how this committee, what role this committee played in the process of suspending the public protector. It's very important. Did we determine that she deserves to be suspended? Did we recommend to the speaker or who speaker who informed the president? Just clarify that so that procedurally we're on the same wavelength.
Thank you, Honorable Olomisa. I was going to come back to those issues, but if you want to quickly clarify that, I'll give to you before I go to Advocate Mbofu.
For the sake of clarity, the evidence leaders have no role in the litigation or the suspension process that has occurred. So we are not in a position to answer the question in any meaningful way.
Thank you. I will respond to the questions later. So I'm just going to park it, Honorable Olomisa. Thank you. I now recognize Advocate Dalimbofu to take the podium. Thank you.
Chair.
Yes, Honorable Mautwe.
Yeah, apologies for coming in before the advocate. Can the Secretary, Temingosi, please allow Mesta's iPad to come through? Mesta's iPad is the president of the EFF.
I'm told it's done already.
Oh, okay.
Thank you, Honorable Mautwe. Advocate Mbofu.
Thank you very much, and good morning, Chairperson, Honorable Chairperson, honorable members, colleagues, evidence leaders, and the Public Protector of South Africa, and members of my team. Chairperson, I noticed that my learned friend, Ms. Bauer, did not address the issue that you raised about the directives, and I'm sure that was just an oversight on her part, but I will try and maybe address where we are on that issue, and obviously if she wants to add something at the end, then she will do so. Chair, let me just start by saying that we have agreed in principle, as you indicated, on a directive. But there are still one or two niggling issues that we need to sort out, which we can't obviously sort out on this panel. That will be done bilaterally between the teams. But I will raise some of those that we think need the attention of the committee, but others I think will be able to resolve them between us as colleagues. Chair, my learned friend, Ms. Bauer, correctly started with a metaphor that had to do with marine affairs and navigation, uncharted waters, and those kinds of allusions. Well, my metaphor that I will start with has to do with a different area, the arts. Judith Sepoma, one of our leading songstresses, has a song called A Cry, a Smile, and a Dance. And my opening words is that if the Constitution was a person, it would adopt that song, a cry, a smile, and a dance. The Constitution would cry because of some of the violations that I will talk about that have brought us to where we are here. But maybe it would also smile because everybody appreciates growth. And as you correctly pointed out, Chairperson, and my learned friend, Ms. Bauer, pointed out, as a country, it is a big moment, constitutionally speaking, in the sense that, as she correctly pointed out, we're really entering uncharted waters. It is the first time in this country that a so-called impeachment process, and I'll explain why I say so-called, has reached this stage that we have reached today. We know that there have been many impeachment attempts for presidents and all sorts of people, and even for judges. But none of them has ever reached this stage that we are reaching today. So today we're starting a completely novel, I think that's another word that I'm borrowing from Ms. Bauer, completely novel area. And just for perspective, there are democracies that are hundreds and hundreds of years old that have not had a process reaching this far, or we were lucky, quote unquote, I think last year or the year before, to witness an impeachment process in the United States of their president. And even there, they were entering many uncharted waters, and we all watched with interest. So I agree with that. But on the other hand, the Constitution, which really should be our guiding light, has been serially violated for us to get here, because there was what one might call a lot of zeal in making sure that we get here by hook or by crook, and mostly by crook. But I will come to that, Chair. The reason why we're talking about the the directive is because when it is approved and sent around, you will see that we have agreed, among other things, that I will do this opening address and another one at the appropriate time. And let me just explain that so that there's no fear that I'll be repeating myself. This address that I'm doing now responds to your remarks, the remarks of my learned friend, and in a way preempts some of what Mr. Ibrahim will say tomorrow. So it is about the situational analysis of how did we get here, where are we, should we even be here, and all that. The second opening address, which I will give if and when the time comes for us to call witnesses, will then focus on the charges. In other words, it will address the second part of my learned friend's address. So today I'm not going to get into Fred and all those things. I'm just going to talk about where we are. When I address you again at that time, I will then take you through our analysis of the charges, of each charge, and broadly speaking, by then we will have a more settled witness list and a roadmap, which obviously will also be determined by the evidence at that stage. But it will also be determined by something I'm going to deal with last. I want to make remarks about a few high-level issues, Chairperson. The first is to assure you that we are here to participate in this process, that our participation is, however, under protest because of some of the issues that I'm going to highlight, which I've called major constitutional violations. But we're here and we're going to participate nevertheless because we represent a law-abiding citizen and public protector. She has always made it clear that she wants the opportunity to assure this committee and the National Assembly, and indeed the nation, that she is fit and proper, willing and able to discharge her duties as public protector. In that process, she has been accused of all sorts of things, including so-called Stalingrad, which is a term that's used by people who hate the Constitution to try and discourage others from exercising their legal rights, which are in the Constitution. Now, that's a very strange accusation, Chairperson, because the irony is that at every time when she has raised concerns about this process, she has been proven right, every time. The DA and Ms. Mazzoni and all those people who are the main sponsors of the motion literally have wanted to do the motion, I think, since the day she took office, if not before. And I'll cut some of the activities in the 2017, 2018, but around about 2019, there was more intense rush to do this. And the public protector wrote a very long letter to Parliament at that time and explained that, yes, we know that Mr. Steenhuisen and others want her to be removed from office. But there's the small matter of the law. And there are no rules that govern the process for such a removal. However overzealous it might be pursued. Eventually, sanity prevailed, and that point that she made was considered. And correctly so, because there was at that stage a judgment of the Constitutional Court in relation to Section 89 of the Constitution, which said exactly that, the majority judgment of Chapter J, in which I appeared to assert the principle that the impeachment process must have its own designed rules. The Speaker of this Parliament opposed our application on the basis that she said then there was Rule 85, so there's no need for this. And other judges agreed with her, Justice Sondo, Justice Mkhwebane, and two others. We succeeded in that application with a split of 7 judges to 4, which asserted the principle that you cannot have an impeachment without rules designed for the impeachment. Once we succeeded in that application, in fact, the last time I was here, I attended as a member of the public, a committee that was trying to design those rules. But the implications of that judgment are going to be clear, and I will probably deal with them in more detail when Mr. Ibrahim is here. So I'm not going to dwell into them, save for this. Justice Chapter for the majority said, it is impossible, I'm paraphrasing, agreed with us that it is impossible to do an impeachment without what he called a preliminary predetermination of the existence of the grounds, right? That you will find at, I think, paragraph 178 of the so-called EFF impeachment judgment. Now, the importance of that for this committee is enormous, because it accords with what you and my learned friend were saying, namely that the task of this committee is nothing more, nothing less than a preliminary predetermination of the existence of the grounds. It's not a removal process, this. This is not a removal committee. That notion is as absurd as saying that when you go, let's say in the criminal context example, when you go to court accused of something, having done something, you call that an imprisonment process. It's not. It's a process to determine A, whether you are guilty. Once that is done, then you can call it an imprisonment or sentencing process or whatever. Or maybe a more familiar example would be labor law. If I steal this bottle from my employer and I'm charged by the employer, the process that takes place is not called a dismissal process, because first it must be determined that I have stolen the thing, and so on, all the elements. Then we have something called a dismissal process or non-dismissal, like you explained, exoneration or condemnation. That's such a fundamental principle that I don't know why people don't understand such a simple issue. well, even if they don't understand it, then at least they must go and at least read the judgment, the impeachment judgment. Crucial. The second issue comes from another case where, again, we succeeded in the Constitutional Court in establishing the principle that this Parliament has a solemn duty to implement seriously with an open mind all the issues that you've raised, or rather to discharge its constitutional duties. In that case, we had gone to say both the Parliament and the President had failed to discharge their duties. The court agreed with us that the President had failed to discharge his duties in the sense that he ignored the remedial action of the Public Protector. But more importantly, it agreed that Parliament had failed to discharge its duty because despite having been given that report, it had basically kicked for touch and done nothing. Again, I'm paraphrasing a long story. But the importance of the so-called EFF1 or EFF Nkandla judgment goes much wider for this committee. And again, it's something I think it's my learned friend who touched on this. And because that judgment for the first time defined the role of the Public Protector. And it said many things about the importance of that office in relation to protecting the Constitution, all the stuff that we all know. But it also said something about the obligations of other organs of state, whether it's the President or Parliament or whoever, vis-a-vis the Public Protector. That case probably actually needs to be mentioned even before the impeachment case, because it was a series. There are three cases that are important, which we will talk about at some stage. It's the Nkandla case that I'm talking about now, the EFF impeachment case, and then the UDM case. In the UDM case, I will mention it in a different context. There, we successfully convinced the Constitutional Court that it was unconstitutional for certain decisions to be taken by show of hands. It was constitutional imperative that certain decisions in Parliament should be taken by secret ballot, or at least that should not be outruled. And that's going to be important, not now. At a certain stage, we will assert very strongly that the decisions in this process must be taken by secret ballot. More particularly, the decision if we get to the National Assembly stage. And I'll explain why in relation to what my learned friend calls the rules of natural justice. But back to the important matter of the EFF versus the Speaker of the National Assembly in 2016, which really, if you like, is what brought us here. Those three cases, in a way, or at least particularly the first two, are what brought us here. The impeachment case, quite literally, because the rules that are governing this process are literally probably 95% transportation from the rules that were designed as a result of the EFF impeachment case, except for a few changes where, fortunately, the Constitutional Court saw through some of the changes that were sneaked in, like the denial of legal representation. And that's why I'm saying the Constitution is probably smiling. Why is it smiling? For the mere fact that I'm talking to you now, Chairperson and honorable members. Because according to this parliament, I'm not supposed to be talking. I'm supposed to be a mummified representative. That's what you approved, that there should be legal representatives who are just going to sit here. And of course, once again, the public protector said that is wrong and took it to court, which is what you do, because you can't beat people up and say, you will listen to my lawyers. That one is quite strange, Chairperson, because it just tells you what we're dealing with here. Let me just take you through what really happened in real life. The DA drafted rules and got them passed on the 3rd of December 2019. And 72 hours later, they put a motion for the removal of Advocate Mkhwebane, but that's a story for another day. We went to court and showed some of the flaws in the rules. Eventually, we succeeded in two major respects in the High Court in the Western Cape. Firstly, that the insertion of the, what they call for shorthand, the mummified legal representatives was unconstitutional. The court agreed with us, hence I'm talking to you today. And also the question of whether the independent panel could include a judge appointed by the speaker. Again, the court agreed with us that that was unconstitutional. But when it went to the Constitutional Court, the one ground, the legal representation ground, was upheld by the Constitutional Court, and the, let's call it separation of powers ground, was dismissed. But an interesting thing happened there, Chairperson. The DA, which was the architect of the rules for all intents and purposes, did not appeal that finding. Very important. The DA did not appeal the finding that I should be talking to you here, having initiated it, because it was a hopeless, it would have been a hopeless exercise. I think even they knew that. But the Parliament of the People of South Africa opposed and said, no, there must be no legal representatives. You, honorable members, on your behalf, you said, no, no, no. Even if the DA says, we're not going to appeal this part because it's fine, but we, the people, do not want legal representation, and you lost. Fortunately, the Constitutional Court would have none of it, and it upheld my right to speak to you now, as I'm doing. Thanks to the public protector who went to the highest court to assert that principle. So the point I'm making is what is called Stalingrad actually has been a series of the public protector assisting this parliament to do the right thing, which is just to abide by the Constitution of South Africa. Anyway, the rules, which then were the product of the process in the EFF impeachment case, resulted in the rules 129R to AF. Remember, what happened is that once the Section 89 case was successful, Parliament then duly inserted Rule 129, A to Q. And then when the public protector pointed out the gap then it inserted the rules R to AF. Now, those rules, one of the things I'm going to raise with Mr. Ibrahim tomorrow is that one of the ways in which I will be pleading with this committee to look into those rules is to compare them with the other impeachment clauses in the Constitution. And I will not go into them now, but we all know that the Constitution provides for the impeachment of a president in Section 89 of the Constitution. It provides for the impeachment of a judge in Section 177 of the Constitution. And then it provides for the impeachment of a holder of a Chapter 9, head of a Chapter 9 institution in Section 194 thereof. This is very important because not only are the rules that you are implementing now a product of the rules that really were Section 89 rules, which shows that these things are interrelated. But there's a lot of learning that one can get from not just from the judgment, but even from the other sections of the Constitution. And an important part of it is the fact that this committee is not a removal committee. Let me say a small thing about the Section 177, because I happen to know a little bit about that because I sat in the Judicial Service Commission. Now, what happens there is that Section 177, you'll see, says the following. I'm talking now about the issue that was raised by General Holomisa. It says, a judge may be removed from office only if, and those words are exactly the same as 194. The Judicial Service Commission finds that the judge suffers from an incapacity, is grossly incompetent, is grossly or is guilty of gross misconduct, and the National Assembly calls for that judge to be removed by a resolution adopted by a supporting vote of at least 2/3 of its members. Right? Exactly the same thing. You can read for JSC, you can read this committee. So a judge, the public protector, may only be removed if the JSC, this committee, finds that the person is guilty of whatever is in your definition, and whatever is in this definition, and the National Assembly calls for that judge to be removed, public protector, by a resolution of 2/3. Exactly the same thing. Now, let me tell you how it happens. What here is seen as a mystery is actually so understood in those circles. Because what really happens, and this has happened now in the case of Judge Hlophe, for example, is that the JSC then goes through something called the Judicial Conduct Committee and then the Judicial Conduct Tribunal, which is your equivalent. And it calls witnesses. We all witnessed that. There was Honorable Griffiths, QC from England. It was this process. And then that happened, and then there was a finding by that committee, just like your process. And then that finding, like yours, was then taken to the JSC. There's something called a small JSC, but that's not important. The small JSC simply means the JSC sitting without the members of the National Assembly. And the reason why we do that is so that when it comes here, those members will not be conflicted, but that's just an aside. So once then the JSC agrees with the finding of the Judicial Conduct Tribunal, at that point, there might be talk of suspensions and what have you, but not before that. It can be done before that, as it has been done here so illegally. It's only once you have that finding that you can even utter the word removal. Because before that, there's no question of removal. As you said, it's exoneration or, depending on the outcome, a removal.
Do you want to take the members to the reading of section 194.3a?
Yes. Section
Just
194.
so that they follow.
Yes. So that correct. So that the comparison actually works. Yeah, right. It's very simple. And let me explain why I'm doing this, Chairperson, with your indulgence. It is because everyone who has spoken before me has said that, and the rules say that this committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner. That's Rule 129 AD bracket 2. So it's your duty. This is not I've been listening to the recordings of this committee and many people saying, no, the suspension thing has got nothing to do with us. We are very focused. Nothing could be further from the truth. Because if you are going to ensure that this is a fair process, you have to be worried. If the public protector was coming here on an ambulance in a stretcher, you didn't say, no, we're just going to continue. You'd want to know why. And this is exactly what's happening. She's coming in that position now because of the illegality that has taken place. So it's the business of this committee to worry about the suspension. The fact that the person you are having here is shackled in a particular way. Her hands are literally tied, and there are efforts to even remove her legal representation, even though the Constitutional Court said she must get full legal representation. But again, that's another story. Let's come to your section, Chair. One of the reasons why this is your business is exactly because, Chairperson, as you say, I must go to 194.3a. How can it not be your business when you are mentioned theoretically, and I put a question mark on that, I'll come back to it, but on the current interpretations that are flying around, you are mentioned directly in that section. 194.3a says the following. It's a very simple section that is being complicated by people for ulterior purposes. The president may, that's also important for another reason. He doesn't have to suspend, may suspend. And if he does suspend, he must tell us why. Because this is not England. There's no king or queen here. Everybody who acts in terms of the Constitution must explain the reason or rationality, especially when it says may, because it means you can go left or right. So you have to say why. Anyway, may suspend a person. Let me pause there, because there's another fallacy that you're suspending an office. What is that? A person, human flesh and blood, with feelings, with dignity, with everything that goes with being a person. From office, and here's the important part. At any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. Right? Yeah. At any time after the start of the proceedings, not just proceedings, of a committee of the National Assembly for the removal of that person. Now, we've all agreed so far that this is not that. This is not there's no committee for the removal of any person at this stage. At least I think there's consensus on that. Now, if that is so, if this committee is not that, well, firstly, has it started? I heard you with respect, Honorable Chair, yesterday on ENCA trying to explain what is exactly this historic thing that's happening today. And it was difficult because you have to make sure you're not saying we're starting the proceedings, but we are.
Which we have started in February.
No, I see Honorable Mulder is not. Yes, no, I will gladly take that. Let me just tell you a joke about that. When we were in court, on this question, there were 4 parties against us on whether the proceedings have started. Mm. If it was a normal court, like a trial, they would have lost the case because all 4 of them had different versions. The DA said the proceedings started when the motion, the independent panel report was passed on the 16th of March. The chairperson, this chairperson, said it started on the 21st of July. Yesterday, he said 22nd February, but that's another story for another day.
We'll clarify that.
Yes. And who else was there? Oh, the president said he just heard from the speaker that it has happened. He doesn't know exactly when it happened, but it must have happened around 21st of July. Okay. And then the last throw of the dice was that it has happened on the 22nd of April when the letter was sent to the public protector. So that's where we are, but I'll be clear. If from those 4, like we can add the normal one, none of the above or all of the above. And maybe you'll tell me which one it is, Honorable Mulder. But the point, Chair, is very simple. The constitutional mothers and fathers, the founders of the Constitution, must be assumed to have, they were not just having a joyride and putting words, plastering words here and there. This is a serious matter of drafting a constitution, more serious than drafting legislation. So one of the golden rules of interpretation is that there are no words that are put there for decoration. All those words have an impact. That you must then understand in the context of what my learned friend said, that there is a constitutional duty to protect the public protector. And I'll come to that. That is the quotation I wanted to give you from the Nkandla case. There is a constitutionally ordained duty for all of us, but more importantly for organs of state, to ensure the dignity, effectiveness of the public protector and to protect her. Now, the constitutional drafters wanted to protect the public protector. There is no doubt about that. Anybody who knows about the so-called certification case in the Constitutional Court will know that the original draft of the Constitution said that the public protector could be removed by a simple majority. The Constitutional Court said no, no, and no. It said for the public protector, yes, for all the other Chapter 9 institutions, you can have a simple majority. But for the public protector and the Auditor General, you need a 2/3 majority. Why? So that she can be protected from the powerful forces that she has to investigate, such as the biggest bank in the country or the president himself. She needs to be protected. So you must look at Section 194 in that light, Chairperson, as Honorable Chair, as a protective mechanism, okay? Or rather, that it came from people, the drafters of the Constitution, whose goal, among others, was to protect, just as we have to protect the judges. Hence, you have the 2/3 majority. Because otherwise, all of us, every time we were unhappy about the judgment, we say, yeah, impeach him or her. It doesn't work like that. the constitutional drafters had to make sure that the threshold is quite high. Now, if you understand that as a philosophy, as a starting point, then you read 194.3a with proper eyes. When the constitutional drafters say, at any time after the start of the proceedings of a committee of the National Assembly, why did they not stop there? Why did they say a committee for the removal of that person? Is this that committee? Are we here for the removal of anyone? Are we? If we are not,
you do know that, just a pause.
yes,
You do know that this committee, so section 193 is about appointment of these heads of institutions. Section 193, it's about the appointments.
correct.
Section 194, and has a heading that says removal from office.
Yes.
It's written in bold.
Yes.
So that's the section. It is about that.
Yes.
And then within it then, as you have taken us through, details the different tasks for the different for the executive, for this committee, and for the NA, and to end with the president if the finding is an adverse one.
Correct.
So section 194, this committee is established in terms of that section,
yes,
which is about removal.
Absolutely. And so was the independent panel, for example. But it would be foolhardy to say the independent panel was a removal mechanism. Of course, it was also under section 194, but was it a removal panel? No.
Yeah. There was a point made. Sorry to there was a point made.
By the way, I welcome engagement.
There was a point made by the evidence leader, which is drawn directly from section 194, that the role of this committee, it ends with findings, reasons and recommendations for that to the National Assembly.
Correct.
The point made there was that we're not a decision-making body. We do work for the National Assembly. Yeah. So if we go to the National Assembly and say, based on evidence and the work we've done, this person is exonerated from what we've received, or we go there and say, we're tabling to you findings and recommendations that are indicating that this person must be removed from office.
Correct.
It is the NA that decides at that point. And you would know that when the NA decides in the adverse, the president is not optional, that he must remove.
Correct.
So I thought there's clarity there. We should be saying the same thing.
No, there's absolute clarity there. There's no doubt. There's 100% or 1000% consensus.
Okay.
But all that what you've said, Chair, does not answer my simple question. Is this or is this not a removal committee? If it is, then we are. It has started. If it is not the committee for the removal,
there is an answer there in the rules. Just
yes,
in rule 129 AD.
129
AD.
Yes.
Section 1.
Good.
If I may read. It says the committee must, when the assembly has approved the recommendations of the independent panel in terms of rule 129Z, proceed to conduct an inquiry.
Good.
And establish the veracity of the charges and report to the National Assembly thereon.
100%. Full stop, you should say at the end. That's all.
It is a full stop, yes.
That's all, Chair. Thank you very much. That is all this committee is about. And that is not me, it's you. It's Parliament that drafted these rules for yourselves.
I'm trying to understand where do you have difficulty?
Yes, I'll assist you.
Okay,
Don't worry.
all right.
The committee, like you said in your introduction, like my learned friend Ms. Power said in her introduction, with which I agree. And as the rule says, it shall conduct an inquiry and establish the veracity of the charges and report to the assembly thereon. Now, the veracity of the charges, Chairperson, is just a fancy word for saying whether the charges are established or not. It's what I said earlier. It's what Judge Chapter said in the EFF impeachment case, that without a sifting mechanism to determine whether, in the case of a president, there's serious misconduct or not, what's the point? You can't have an impeachment process. But in fact, he puts it very clearly. I'm sorry if you will indulge me.
No, go ahead, go ahead.
Yes, I'm very sorry for this. You see, while I'm looking for this section, one has to understand this thing called impeachment is what causes the confusion. Impeachment is just a fancy word for removal. Okay. So if you go to section 89, to come to your point, the heading is removal. If you go to section 177, removal of a judge. 194, removal of a head of an institution. So that doesn't take the debate any further. The question is what in that process, who must play what role? Not what the process is called. But so if you understand that impeachment is a synonym of removal, then you must read paragraph 179 of EFF versus Speaker, National Assembly, 2018, bracket 2, SA 571, decision of the Constitutional Court. This is what the judge says then, for the majority. For the impeachment process to commence, okay? So that's exactly the thing that is envisaged in 194.3a, right? Commence is start, it's the same thing. For the impeachment or the removal process to commence, the assembly must have determined that one of the listed grounds exists, which is what we're busy with now. Must have, in other words, in another process, which is where we are. The impeachment process then commences. Okay, so the impeachment process is going to commence one day if you, all of us here with respect, find that one of the grounds exists. I mean, it's so simple. It says at 178, the judge said, since the determination of these matters fall within the exclusive jurisdiction of assembly, it and it alone is entitled to determine them. But here's the important part. It says, this means that there must be an institutional predetermination of what a serious violation of the Constitution or the law is. The same must apply to serious misconduct or inability to perform the office. It can't be simpler than that, Chairperson. There must be an institutional predetermination. That's what we're busy with here. It's the institutional predetermination that was ordained by the Constitutional Court. And the impeachment process cannot commence until that has been done. So this notion that the commencement can precede that predetermination is, with the greatest respect, absurd. But anyway, somebody advised others, or rather the Speaker of Parliament and the Chair, I know, hold a different view from the court papers. But that's the reality.
But I'm listening.
No, I know, Chair. I don't doubt that. But let me just maybe make it sound a warning that Justice Chapter said in the same judgment that If the so-called removal is done without following what he has said, it's just play. Because he said that removal will not be a removal in terms of the Constitution. So it's fine. We can go through this. We can indulge each other and speak for the next couple of weeks. But if we, as the law is very clear, for example, that fairness to the public protector in particular is not one of the things that is here. She's sitting here. The Constitutional Court, no less, said she must be given full legal representation. She gets suspended unlawfully. She has not been able to prepare for this process. Her emails were blocked until last Friday when we protested. So to say that the suspension has nothing to do with this committee is, with the greatest respect, a fallacy, because it does. But again, let's put that on the side. Because all these nice arguments, by the way, are going to be aired on the 25th and 26th, as you know, Chairperson, of this month, in about 2 weeks' time, in the High Court in here in Cape Town. And because there, it's not going to be the thing of the interdict and what have you. Is this what we're debating now? Have the proceedings started? Yes or no? If they have not, then has the Section 143A been triggered? In other words, the suspension process. If not, then the unfairness is patent. So I'm only addressing it to you. I know you are not the president, or you don't speak for him. I'm only addressing it to you. Let me emphasize, only insofar as it affects your obligation to have a process that is fair and reasonable, which obligation you imposed upon yourselves. In 129, the one that follows the one you just read, Chair. The committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner within a reasonable time. By the way, as one of you said, the rules of natural justice, as you know, Chair, and I'm sure the honorable members have heard this many times, otherwise they wouldn't be here. The rules of natural justice are two. They come from Roman times. One is called Audi Alteram Patem, which somebody was trying to pronounce the other day. It simply means, again, is fancy lawyers' language. It just means the other side must be heard. And the other one is called Nemo Iudex in rem sua. And again, lawyers just like to be difficult. All it means is that no one can be a judge in his own cause. It's called the rule against bias. Okay, so when you say in that section that you must ensure fairness, it means you must ensure both of those rules, Audi and Nemo Iudex. So this issue about suspension falls into this, your second obligation. And I'll explain how. Because not only is this suspension premature, as I've explained, whether you agree or not, but let's call that the prematurity ground, or ultra vires, another Latin phrase, unnecessary Latin phrase. But it is also, it offends against the rule against bias, in the sense that the person who did that suspension is a person who's being investigated by the public protector. And our courts have said that that is bias or potential bias, or which is more important, a breach of Section 96(2)(b) of the Constitution. That's why we had the Zondo Commission. I was in that case. I argued vehemently that the president cannot appoint or select the judge who's going to chair the commission. And we did that successfully. Why? Not imagine a judge, and my learned colleague, Mr. Semenya, was my opponent, made this point, and it was a very difficult point to say, but how can you say the president may not appoint a judge? Because a judge is a judge. He's presumed to be impartial. But our court said, no, we know that a judge is a judge. But the mere appearance of the fact that this president, who's being investigated by the public protector, will be the one to, is just too ghastly to contemplate. So I'm saying that principle. Now, that was a principle that is so far removed. Now, if you introduce pala and all those things into that mix, you are now talking about an investigation into.
Yeah. Can I make the point that this body is not a suspending body?
No.
In terms of Section 194. I appreciate and respect the fact that on the 26th and 25th of July, these are the kind of points you will be making in court, because that's where it is relevant, and not necessarily in this body.
No.
Because we have no role in the suspension of any of the heads of this institution.
Yes.
It's clearly stipulated whose role that is.
Okay, thank you, Chairperson. Please, if that I've said that, I've listened to that being said in this committee repeatedly, it is wrong. Okay, it is wrong for reasons I've explained. You have a duty to ensure fairness. You've agreed. Secondly, this committee, on your version, is mentioned in the suspending clause. All right. So if this committee wasn't here, there would be no suspension. At least do we understand that?
We trigger the suspension.
Yes. So
once our process starts.
Absolutely. In other words, the two things are like Siamese twins. No committee, no suspension. The only way under the sun you can ever suspend the public protector is if this committee has started. So how can the two things not have anything to do with each other? Because it's like saying, I was going to use an example, but
you can. It can be translated.
No, it's fine. But it's that. It's just absurd, that notion that this committee, whose activities trigger the suspension, has nothing to do with the suspension. What is that? But anyway, the point I simply want to make, Chair, is that I don't want to go into the legalities. I want you to at least accept that you have an obligation to ensure fairness. And fairness includes both the rule against bias and conflicts of interest, as well as the rule for a hearing. Those two are inextricable. So if there's a conflict of interest, it's your business. If there's a lack of hearing, it's your business, right? If there's unfairness of any kind, it's your business. Self-assumed by you, self-decreed by you in this thing called the rules. So let's please, this notion that this committee has got nothing to do with fairness as it relates to the public protector must be banished from anybody's thoughts. Okay, now let's then go to the public protector's role, or rather why she should be protected, Chairperson. This is what Mkhwebane CJ said at paragraph 51. Yes, among those to be investigated by the public protector for alleged ethical breaches are the president and members of the executive at a national and provincial level. So take that as a background. And the court said in biblical terms. And that is the public protector. She is the embodiment of a biblical David that the public is, who fights the most powerful and very well-resourced Goliath that impropriety and corruption by government officials are. The public protector is one of the true crusaders and champions of anti-corruption and clean governance. And then it says, in the execution of her investigative, reporting, or remedial powers, she is not to be inhibited, undermined, or sabotaged by those that she's investigating. It says, her investigative powers are not supposed to bow down to anybody, not even at the door of the highest chambers of raw state power. That's just a euphemism to say the presidency. The highest chambers of raw state power. The predicament, though, is that mere allegations, note that, mere allegations and investigation of improper or corrupt conduct against all, especially the most powerful, especially powerful public office bearers, are generally bound to attract a very unfriendly response. She's a witness to that. An unfavorable finding of unethical or corrupt conduct coupled with remedial action will probably be strongly resisted in an attempt to repair or soften the inescapable reputational damage. It is unlikely that unpleasant findings and a biting remedial action would be readily welcomed by those investigated. And that the court was saying as a precursor to why she must be protected from those powerful forces, including the president, by all of us, because she must not be easily sabotaged. So the duty to protect, Chair, is really what I'm asserting. And that you will find in the same judgment. Oh yes, is the obligation at paragraph 67. And rather 66, and the fact that her investigative power and remedial powers target even those in the throne room of executive raw power, it is just as revealing that the Constitution requires the public protector to be effective and identifies the need for her to be assisted and protected to create a climate conducive to independence, impartiality, dignity, and effectiveness. So let me pause there, Chairperson. This is another reason why your assertion that this has nothing to do with you is wrong. Why? Because you are an organ of state, you are parliament, let's say, you are an organ of parliament. So for all intents and purposes, you are the parliament. You, under sections 181 and 182 of the Constitution, have a duty, not a nice to do, okay? You have a duty to ensure, so this is a third reason why this has a whole lot to do with you. You have a duty and an obligation, and actually that's why you were found guilty. When I say you were, Chair, I don't mean literal, maybe you were not even here. That's why the National Assembly was found guilty of breaching its obligations. Because it says at 181.3, other organs of state, including this committee, through legislative and other measures, must assist and protect these institutions to ensure the independence, impartiality, dignity, and effectiveness of the institutions. So you have a constitutional obligation to protect the public protector. 181, sorry. 181 bracket 3. Yeah. Okay. So that's another reason why it's your business. Now, this is what then the court says. The obligation to assist and protect the public protector so as to ensure her dignity and effectiveness is relevant to the enforcement of her remedial action. The public protector would arguably have no dignity and be ineffective if her directives could be ignored willy-nilly. The power to take remedial action is so inconsequential. That was the part, remember, in those days, the controversy was whether it's binding or not binding. And the court was explaining why it must be binding. But that binding effect was traced directly, Honorable Chair, from the duty that is among all of us, particularly organs of state, to protect the public protector. So you can't, the day this parliament says, washes its hands and say, well, you can be mutilated and what, that's got nothing to do with us, like Pontius Pilate, then that will be the day that this constitution must be thrown into the dustbin. So that's how we got here. We got here, in summary, Chair, through a process of our constitutional court, as it should, giving teeth to the constitution. Because a constitution, if we were to cover everything in this constitution, it would be thousands of pages. It would fill buildings and buildings. A constitution is just a framework, a skeleton. What breathes life into it is this kind of interaction and so on. Otherwise, and the constitutional court's role is exactly to do that. And my learned friend said something which I don't agree with, by the way, but that will be for the argument at the end, about the binding effect of judgments. The binding effect of judgments, or the rule called stare decisis, another Latin phrase, applies to the binding effect of judgments to courts, right? It is to ensure that there is certainty and that one court doesn't say something and then contradict each other. But that binding effect must be distinguished from the effects of Section 165 of the Constitution, which says that all of us, if there's a court judgment, we must all respect it and so on, in the same way. Actually, 165.3, I think, is exactly the mirror image, Honorable Member, of it's the mirror image of the one that I read. And that's another important point, which I'll make at another time. Because 165.4 says, organs of state, through legislation and other measures, must assist and protect the courts to ensure the independence and dignity, accessibility, effectiveness of the courts. So you might think I'm reading the same thing. That's because those provisions are exactly the same. So the duty we have to protect the courts is exactly the duty we have to protect the public protector, exactly, word for word. And but the issue I was making, the point I'm making was you are not bound by court judgments. That's wrong. You're not in a process like this. Are the court judgments irrelevant? No, I'm not saying they're irrelevant. Do they happen? Yes. Are they there? Yes. But if they're binding upon you, then what are we doing here? Let's all go home because the court has spoken. No, that's just so wrong. You are here to do your own assessment, as you correctly pointed out, Chair, to your credit, your own assessment of those issues. That must be, please, I beg all the honorable members, that point must be understood.
And the members of this committee are clear on that.
Well, not if they listen to the evidence leaders, because my learned friend said that you are, and that's why I'm emphasizing this, that you are bound by those court judgments. No. Even the independent panel with which we agree so much said the following at 103.1 of their report, page 42. We are alive to the fact that the courts dealt with the conduct of the PP in a different context, right? Mostly whether the PP's reports are reviewable. The question before us is different. The question before you is also different, Honorable Chairperson. And they say, it is whether there is a prima facie evidence that the PP has committed misconduct or is incompetent. In front of you, it's more than that. It is whether she's guilty of misconduct. But the principle is the same. The question is different. But this does not mean that the factual findings of the courts cannot be relied on. I've just said that. To the extent relevant as prima facie evidence of misconduct or incompetence. For example, said the panel, a patently incorrect interpretation of a statute may constitute an error of law, in other words, a justifiable error of law, but it may also constitute prima facie evidence of incompetence. Considered. In these circumstances, the finding of the cause and respect of the PP's conduct have been taken into account as detailed below. That's all. That is the Bible you must go by, not a Bible or false prophecy that that you are bound by the courts in this stare decisis type of thing. Where a lower court is bound by another court, doesn't matter even if they think we don't know what this other court was thinking, but if it's higher than them, then it's binding. Okay, very important, crucial distinction that you must make. You must determine with an open mind all the things that were said by my learned friend, Ms. Power. Open mind, open, clean slate, all the metaphors that were used. Whether, having listened to both sides, having listened to the witnesses that are going to be called, having listened to the public protector and her witnesses at that stage, whether she's guilty or not guilty of misconduct as defined by you in Parliament. That's all. That is all. You're not bound by anything. You come hopefully with a clean, on a clean slate. But while we're on that, let me make the next point, which is why you said, I think, Chair, and I salute you for that. Nobody must come here with a predetermined outcome. Fairness and rationality, a rigorous assessment of the facts, and so on. Those were your words. Well, a predetermined outcome is another aspect of the Nemo Iudex rule. Because what would be the point of going to a court, for example, if the judge was just watching you and thinking, you can talk until you're blue in the face. Before you open the mouth, I know exactly what I'm going to do. Then again, we're wasting each other's time. I'm sure these honorable members have many important tasks to perform than to come here and perform a charade, and we sit here and talk for weeks and weeks and weeks. And then at the end, we know exactly what's going to happen. That's what you were warning against correctly, Chair. And that's why I'm saying that the UDM case at the appropriate time becomes important. Because let's not kid each other. If what is going to happen here is that people are just going to do that which they were going to do anyway, then what are we here for? We might as well just count. We know the DA has got so many members, the ANC has got so many members, the UDM has got so many members, and so on. Let's just call a 5-year-old child to do the arithmetic, and then we're done. Okay? But if we're going to sit here for weeks and weeks and listen to evidence and fly people here to be listened to and so on, then it must be done genuinely with an open mind. And unfortunately, one of the ways to ensure that that happens is by secret ballot, because the court in the UDM case said that is a method by which
the secret ballot is a National Assembly issue.
Well,
as a committee, ours and the things that you have raised in all the meetings that we have had, what I was raising in my remarks are the sentiments of this committee.
Yeah.
all of them.
Well,
it's about bringing all of them into one. So,
Yeah.
so that you might be preaching to the converted in that sense. I'm not about to rush you, except to say, because when you started to say you are here under protest and you are going to ventilate what these issues. And it is my understanding that that's what you're ventilating, that protest. I think that category, I think we've had it.
Yes. Well, Chair, let me just say this. I accept without any quibble the fact that the issue of the secret ballot may be more relevant for the National Assembly, but you are also members of the National Assembly. 1, 2.
And it might not be relevant depending on the outcome that comes out of this
that's
committee.
what I said.
So we don't want to look there.
No.
It's not our space.
No, you want to look there. Let me tell you why. Because you have to do a report. You said it yourself. At the end,
and the report might exonerate. There's no secret ballot.
Yes, but if I said that an hour ago, didn't I?
You did.
I did. Thank you. So I said that the reason why I said the UDM case is not as important as the other two is because it may become relevant should if you play the record, you'll realize that I said exactly that, which is what you are saying. So I'm saying when you do a report, if and when you do a report, bear in mind that fairness will require that we don't do a futile exercise of bean counting and we know the outcome. Because quite frankly, if that is the case, even here, I'm saying this with all seriousness, Chairperson. Even here, we might as well just pass a piece of paper and say who wants to remove, who doesn't. That's it. Because we're not about to waste the time of these honorable members and South Africans with a predetermined outcome. I'm making the point that you made, but maybe you prefer it when it's put in these Latin terms. But it really, the point you're making is what lawyers would call nemo iudex in rem sua. No pre-charge. You cannot pre-charge a case. I was just underscoring that point you made, and also relating it to the question of fairness. Chair, I think I've covered most of. Let me just make sure that.
You did indicate you want to speak to the directives.
Yes, that I'll do that at the end. Yes. So just to round off this point, bias. Bias is a no-no, is an enemy of fairness. That should go without saying. But here, I've already indicated that it was the Speaker and the Parliament that said the public protector should not have legal representation. I'm sorry, I'm overstating. Should not have legal representation with a voice. The chairperson of this committee has made certain remarks which we will refer to at the appropriate stage. Some of the members of this committee, at least of the National Assembly, have made remarks. One of them said when she was suspended and is a leader of a party, that party was cracking champagne. That's impartial. Those are the impartial people who are supposed to be subjected to. They've written in court documents under oath that she's guilty of misconduct. And and my learned friend said they must have open minds. Well, good luck with that. Other members, even in the previous parliament, actually one of them said she must do the right thing, just resign. This committee, you chair, and the speaker have now entered the fray to say she must not be represented in the litigation by the attorneys of her choice. You've brought something called a Rule 7 application to ensure that she is left helpless and defenseless. So much for neutrality. And all sorts of other people have joined in, egged on by you, Chairperson, and the Speaker. And by the way, that's also not a coincidence. It is, with the greatest respect, fair, Chairperson, for you, and I'm not saying you as a human being, sitting there as a chairperson, to tell us that this committee, this thing that has been peddled, or that the committee has nothing to do with the suspension. Why was there a suspension? It's because the Speaker of this Parliament wrote a letter on the 10th of March to the President to say that this committee has started. There's nothing in our constitution that says she must do that. Nothing. Nothing in these rules that says she must do that. She did it on your behalf.
And nothing prohibits her to do that.
No, thank you.
In the constitution, nothing.
No. Well, if you believe that, Honorable Mulder, then please, I don't want your assistance later. Let me tell you.
You're going to need it.
Yeah, no, I don't. Let me tell you, that is sacrilege. It does not work like that. Constitutional democracy, this thing called the rule of law, is exactly the opposite of what you're saying. The rule of law says that there's a case, I will find it for you in due course, which says that the rule of law does not say you can do all that is not prohibited. That should make anyone who believes in a constitution, it should make your blood to boil. No, the rule of law is the exact opposite. The rule of law says public functionaries, people who derive their power from the constitution, not from owning your house or whatever. If you derive it from the constitution, can only do that which is authorized by the constitution, not the opposite. You can't say, oh, well, the constitution says, it doesn't say I might not rob a bank. And therefore, yeah. No, please. The rule of law as evidence in the...
Advocate Mpofu, just a pause there.
Yeah.
So at the point when the National Assembly, let's say for argument's sake,
yes, adopts
a report,
yes,
with findings, and the committee is recommending removal,
right,
it adopts that.
Yes.
The constitution does not say that the speaker must write to the president, because
yes,
that's your next point. It's
yes,
not in the constitution.
Yes.
And the speaker, because the president can't just sniff it in the air that the NA has decided on
watch
this
it in
issue.
the news. Yeah.
Yes,
yeah,
it can't.
100%.
So why would you want to stand on this point that she should not have written this letter,
yes,
to indicate that this House, the National Assembly, through its subcommittee, the proceedings have started?
You see, Chairperson, my honorable Chairperson, there is something called the Constitution. And then there's something called legislation. And then there's something called the rules. Okay.
And regulations.
Right. All of those are subject to. So once once you have rules, that's why we had the first case about legal representation, because we're saying the rules are unconstitutional to the extent that they don't allow legal representation. So what do you do as a parliament? What you do is, if you think about that situation and you say, well, one day the committee will start and the president will be sitting in Dubai or whatever, not knowing what is happening. And therefore, the speaker or the chair, or me, or Honorable Olomisa, or Honorable Mulda, must inform him. Then what you do, Honorable Chair, is you do what you did in Rule 129T, which says, answer your question. When the motion is in order, that's when your motion is in order, the speaker must, 1, immediately refer the motion and any supporting documents provided by the member to an independent panel appointed by the speaker for a preliminary assessment of the matter. That's not something the speaker just wakes up and does. It's here, you decreed. And B, inform the assembly and the president of such referral without delay. Okay? So here it is, the duty to inform the president without delay of the motion. That answers your question. Where in this document is where it says she must inform the president that the proceedings have started, prompting him to, there's no other reason to do that except to prompt him to suspend. Where? But where does it come from? It's not here. So let's not kid ourselves. The only reason the Speaker of this Parliament wrote to the President on the 10th of March without any lawful authority, without any authority from the Constitution or the rules, was to say, wink, wink, suspend her.
But you agree with me, that point you have already ventilated in court.
No, it doesn't matter if I've ventilated it anywhere. I'm ventilating it here for the purposes
and there's an
committee.
outcome in that regard.
No, there's no outcome. There's no outcome, sir. The outcome is going to come on the 27th of July, probably.
And you will have that opportunity.
Yeah.
Because the body that you are addressing now on that particular issue, you're carrying the matter as part of Part B, which are the merits of the case that you're tabling.
Yes, yes, Chair, you're 100% right. The only relevance it is to you, with the greatest respect, is whether you, and I say in the collective, as this committee, feel that despite all those issues, on your own volition, okay, there is nothing stopping this committee from itself, in the interest of its own rules of fairness and so on. For example, saying that these issues, from what we never, obviously never looked at the sections like this, and you have to make your own decision as to whether you preempt the outcome of the court case you are referring to or not. We are here. We are ready to rock and roll. Okay? We are very ready. But we just want to tell you where you are leading this country and this parliament, to a bottomless pit and a cesspool of illegality. That's all we have to, we have to discharge our duty. We can't stop. It's a free country. The committee will make its own decision. Good luck. But let me then make the last point, Chair, which is this. And that ties up with this issue of the directives. As I said, there are issues on the directives that, as colleagues, Ms. Bauer and I have worked together for decades. So I'm sure we'll be able to iron those issues out as colleagues. But there's one particular issue which I want to place before this committee by agreement, and she'll confirm, because we raised it and she correctly said that's not within our power, it's for the committee. And I want to leave you with that issue. Another serious issue for you to consider, and it is this. What are we doing here? I'll call it the narrow approach or the broad approach. And you have to make up your minds which one you take, and the consequences will follow later. But there are two approaches which can be taken, Chair. And it goes back to this uncharted waters story. And for this, I'm on your side, because you are the guinea pigs, quote unquote. Other people who do this later will make it look so easy. But you, unfortunately, history has put you here to be the people who have to do the first impeachment. History has put all of us in this room right now. One of the issues you have to decide is whether you are going to do this inquiry on the basis of the original motion by Ms. Mazoni. That's what I call the broad or wide approach. Okay. In other words, you take Ms. Mazoni's motion and inquire into all the issues that are listed there. Oh, well, I can't accuse my learned friend because she has not expressed any view correctly, because she's an evidence leader. But it is my privilege to express a view. Our view is this. This committee cannot, should not, must not take that wide approach. This committee by law is enjoined to take the approach that says that what you are going to investigate are the issues that have been defined by the independent panel. Let's call that the narrow approach. Now, this is crucial, Chair, and that's why I left it to the end, because we cannot move an inch from this point until that question has been answered. I'll tell you why, because it will determine what witnesses are called, what witnesses we call, all sorts of things, how long the whole thing is going to take, what's relevant, what's irrelevant, and so on. Now, if anybody has got the idea, and I'm not saying there is such a person, but if there is any person who harbors under the idea that what we must deal with here is the Honorable Mazoni motion, then that person is wrong. I want to say it here clear. Because the independent panel is a mechanism devised by this parliament. One of your advocates, I think Advocate Breitenbach, who represents parliament, called it in the previous cases a double sifting mechanism. The first sifting mechanism is the independent panel. The second one is here. And he correctly pointed out that these are ways to ensure fairness and so on, all the good things on paper. But what would be the point of having that double sifting mechanism and even go as to get a judge and advocates and so on, if it's just a futile exercise? The whole point of going through that exercise was to say, is there or is there not a prima facie case in respect of these charges? To make it simple, Chair, let's assume there was one charge. One. And that charge was the public protector robbed the bank, at Standard Bank or whatever. and therefore she must be impeached. Boom, Parliament, deal with it. The Speaker takes it to the independent panel. Indian panel does what it does, audi alteram, what have you, and then it comes back and say, no, this is, if you excuse me, nonsense. This is the public protector was actually overseas when the bank was being robbed. Then what would have happened? That would have been the end of the matter. I think anybody can understand that. There's no way that the National Assembly would have made us to gather here to do what? Because the independent panel has already told us that the public protector was not even in the country at the time of the bank robbery. So transpose that mentally to where we are now, where they are, and I'm just using a number, don't hold me to it, 20, let's say there are 20 allegations or charges. And the independent panel then says, this 8, nah, there's nothing here. But this 12, there's a prima facie case. Again, please, you must never allow lawyers to intimidate you. These Latin terms actually mean very simple things. Prima facie case simply means you have a case to answer. I don't know why people want to have to use Latin here. So the independent panel has said, on these 8, we're just making it up, Chair, just to make it easy. On this 8, there's no case to answer. On this 12, there's a case to answer. Why on earth would this committee say, no, we want to probe the 8? Why is 8 different from 1? So let's, I'm sure the honorable members have read the independent panel report. The most prominent example of what I'm explaining now is the case of the Baloyi matter. You'll find that in the report, I think it's number 9. Sorry, Chair, I'm winding down.
Is that the former COO?
Chairperson? 187. Thank you, TP. Yes, it starts at 186. Yes, paragraph of the report. But I won't bore you with the. I'll just go straight to the end. 197. The independent panel says, after having analyzed the whole thing, including, by the way, the fact that that case is still before the Constitutional Court.
You said paragraph?
197. The section is 186 to 198, Chairperson.
Okay.
But I'm reading from 197, it's a short sentence. They analyze, and then they say, in the circumstances, we find that the Baloyi matter does not raise prima facie evidence of incompetence or misconduct. Full stop. So let's go, it's the bank robbery story. So in the light of that, why would we sit here for weeks and weeks to probe the Baloyi matter? In my respectful submission, that would be a mighty waste of time. So when you deliberate on this question in your own time, please liberate us as to what exactly we're here for, because we need to know, as you may appreciate, in the interest of fairness, for the case, for preparation, witness identification and all that, whether we're meeting case A or case B. And as I say, I sympathize with you.
And advocate, in your practice, you would know that evidence overlaps.
No.
So how do you deal with that when it overlaps in that way?
No, that goes without saying. No, evidence, yes, no, that's true. The evidence overlaps, but evidence must never be allowed to overlap into irrelevant matter. That's the constraint of the overlap. The minute you lead,
and you wouldn't do it for completeness sake as well.
You might. Let me give you an example, Chair.
Okay.
In agreement with you, by the way, in part agreement with you. If, let's say, there were two charges. One is the bank robbery, the other one is swearing at a member of the public who wanted to complain to the public protector. Okay? Yes. Of the witnesses.
I didn't hear that.
No, sorry. No, the public protector was reminding me of a different point, which I will make in the other.
Okay.
In the other, that.
Go ahead. It's fine.
Yes, it's about an example that is live. Yeah, one of the so-called witnesses here assaulted a member of the public who wanted to complain, but that's another story. I'm saying, let's say there were those two. Then, for some reason, Chair, I say to you, but Chairperson, the bank robbery has been cleared by the independent panel. But the independent panel said on this thing of assaulting a member, there's prima facie evidence. Then you're 100% right, Chair. I can't now say when we're dealing with the assaulting the member, if it so happened that it was at that same bank, you understand what I'm saying? Then say, no, you can't mention anything about the bank. Remember the independent, that would be absurd. That's not the point I'm making. No, the point I'm making is completely different. I am saying, that's why I took you to the example of one charge so that conceptually we're on the same page. I'm saying, why would you and the other honorable members, with respect, Chair, assuming the only issue here was the balloimet, let's say, and the independent panel established by this parliament says, in the circumstances, we find that the balloimet does not raise prima facie evidence of incompetence or misconduct. Isn't that, and I'm asking this rhetorically, the end of the matter? It is. It's a question that does not need an answer. So from that principle, I'm simply saying, when you deal with it, and again, Chair, believe me, I appreciate the engagement, because the engagement assists me in explaining. So don't think that I'm going to say, no, you're interrupting me.
You're also aware that this committee does not rubber stamp the panel's report.
I'm fully aware, but the panel, it doesn't rubber stamp, but the panel is not a football match, meaning signifying nothing. All right. If it is, we must be told. That's fine. Well, we're happy. But if the panel was not a sifting mechanism, as your submissions were in court, then it negates what you were saying, Chairperson. For example, by parity of reasoning, it would mean that this committee can say that the public protector is not guilty of anything, but the National Assembly must convene for a 2/3 vote for what? So I mean, this is really, this is simple, a simple choice of either we respect the work of the panel and then and deal with the issues that they've taken. By the way, Chairperson, they've taken trouble to assist this committee by putting something called Annexure A at page 117 of the document. It says, finding in relation to the charges. As related to the charges, the preliminary assessment of the panel as per National Rule 129X1B and CV are that there is prima facie evidence of incompetence in respect of the following charges. Then they list them. And then at 263, as related to the charges in the preliminary assessment of the panel as per NA Rule 129X1B and CV is that there's prima facie evidence of misconduct in respect of the following charges. And then they list them. So all I'm saying is that anything that is not in that list should not be, but it doesn't matter what I say. What I'm really saying is that you need to tell us as a committee which is which, because otherwise we don't know what we're doing here or how far it goes. And those are matters that this committee may want to either take legal advice, or if they feel do it by the vote, it's fine. But whatever decision you make will have clear consequences as to what happens next. The last one, Chair, lawyer, when a lawyer says finally and lastly, you must be careful. But this is a quick one. Okay. There's a rule about self-incrimination. Sorry. Okay. This one is a small point, I can assure you. It's not as big as the previous point. In terms of the rule against self-incrimination, the panel said, and remember this relates to, and I've not raised this with my learned friends, but it relates to the CX matter. You may or may not be aware, Chairperson and honorable members, that that matter is a subject of a criminal case. And we raised this with the panel, and the panel's answer was that, well, you may not be compelled to answer questions in civil proceedings, which these are supposed to be, if there's a pending criminal matter, particularly if you are not compelled to answer that. That's just the law. And it was correct. But the question, it then raises a question, begs a question here as to whether we're compelled. Can the public protector come here and say, I don't want to answer? I don't think so, because she accounts to Parliament. That's what the Constitution says. So that's another matter on which you might want to get some advice as to whether she will be entitled to refuse to deal with certain issues on the basis that they are subjects of pending criminal proceedings. I'll just leave it there. But the big issue, I mean, that can even be resolved in due course. The big issue is the narrow and wide. Let me just have a note from one of my learned friends. Okay, yes. I'm sorry. Okay, one of these issues I think belongs to the issues that we will deal with our learned friends, the issue of the bundles, which we cannot access and so on. I think that we can deal with at the level of the professionals. But the other issues which are raised by my learned junior, Ms. Mkhwebane, is that I've raised this, but she wants to emphasize the fact that her emails were only opened on Thursday. What was the date on Thursday? The 7th. Yes. So Thursday, yes, which was the 7th. That's almost a month from the date of suspension, which was the 9th of June. Okay. So for a month, she couldn't access her emails. She couldn't prepare for this, quite apart from the other side issues that were provoked by Parliament about lawyers and all that. So she has not been able to do that, and that is a direct consequence of the suspension, which you say has nothing to do with you. It does. Her PA was removed and all sorts of things. And she's not quibbling about that, by the way. She's a very strong and formidable woman. But for anybody to think that in a constitutional democracy, you are allowed as Parliament, as a speaker, as the chairperson of this committee, as the president, Nogal, to say, we want to litigate against this person about her alleged unfair suspension. One woman against all these powerful people. But you know what? Let her be shackled, put handcuffs on her back and shackles on her feet, and then let's have a fair boxing match. That is repulsive, because you cannot do that. Why does the speaker and the chairperson of this committee care or wants to interfere with the affairs, internal affairs of the Office of the Public Protector, whether they brief this one or they got this lawyer or that lawyer? Why? What has it got to do with you? Because if that is the case, then let's say, okay, fine, then let's be fair. Let the Public Protector not be represented, and the speaker will also not have legal representatives, and the honorable chairperson will also not have legal representative. That's a fair field. And the president. Let's all go. Man to woman or man to man or whatever. But you are not allowed, in fairness, to want to shackle the individual, the one solitary woman who's the biblical David against all you Goliaths. And now you say, no, this David must, on top of it being David, she must now be also handcuffed. Is that fair? No, it's not. And this is the conduct of this parliament on behalf of me as a citizen. No, I'm sorry. That conduct cannot be accepted. But we want to put it out there that she has therefore been completely sabotaged, to use the word that Mkhwebane CJ used. She has been sabotaged in preparation for this, and she has been sabotaged in preparation for the 25th and 26th, because you, Chairperson, and the Speaker have said that she must not have lawyers there, or whatever you've said. And so that means that you wanted to double shackle her for this process, but also for the court process. Why? The question is why? In whose interest is it that the Public Protector must not challenge her unfair suspension? Is it in the interest of these honorable members on whose behalf you speak, Chair? No, I would dare say. Is it in the interest of South Africans in general? No. Is it in the interest of fairness and justice? No. In whose interest? Must ask that question. Is it that she must not investigate the things that she's investigating now? And on top of it, she must not even be allowed to challenge her suspension. In whose interest? It is not, I can assure you, in the interest of the people of this country, or in the interest of democracy, or in the interest of this document. Those are our submissions, Chair, and we will thank you for the indulgence and for the engagement. The rest of the directives are not, unless if Ms. Power corrects me, I think that was on the directives, the only issue we wanted to refer to you. Let me just thank you for the note. They sent us a summary. Oh yes, there's another one. I don't know if it has the definition of a member. We put a proposal that a member means any duly appointed and qualified person who serves in the Section 194 committee. And that was merely just to differentiate. That it doesn't mean, I know I've never been in Parliament, but I know that
you have been.
Yeah, well, not formally. No, that in some committees, members, any member of the NA can come. Yeah, it's just to ensure that this one is a special.
So you're raising that in trying to address that.
Yes, that's all. Yeah. Then the next one
You do know that our rules, because the NA is supposed to be.
I know, they apply
okay.
here, yes.
Okay.
But, it's something we have to resolve. We don't know. As I say, we're not coming from a point, unlike the ones where we say we're proposing this. Here, we are under your guidance. Yeah. So if anybody can just rock up and ask questions, then so be it. Yeah. Then we'll have to challenge those rules, not you. Yeah. And then we said 2.5 as qualified in the report of the independent panel. Okay, that's a point I made earlier. Yes, the thing about the 5 days of her announcement, Nas, I don't think do we need to refer that?
The issue was she's got to answer questions that's posed to her. And the proposal was that she would have to answer it when she testifies. And I think you wanted to say, well, if she opts not to testify, that she then has to answer those questions 5 days
after.
that date
Yes.
after.
No, I know what I said. I'm just saying, is this an issue we need to refer to the committee or we can resolve?
It's not an issue that I can agree on.
Then let me raise it, Chair. Yeah. Again, this for me, unless it's a non-issue. One of the rules, 5.7, the draft rules, which you have seen, maybe the other members have not seen. Basically, I'm paraphrasing. It says that
just refer to them as directives.
Directives.
Separate from the rules.
Yes. I'm sorry.
Yeah.
Yes. The one of the directive 5.7 says that the public protector may be asked a question at any point, right? And that she must then, if she so chooses, answer that question within 5 days, right? Unless she indicates that she's not going to give evidence, okay, which is a fair rule, I think. All we were adding there was to say that it must be 5 days of the question or 5 days of her making the decision whether she's going to testify or not. And that's just to do away with an absurdity where, for example, Honorable Mulder asks a question, then we say, no, we're taking the 5-day rule. And then only in September, she decides that she's not going to testify. Then we say, oh, but my 5 days expired in July. Yeah, that would just be an absurdity. So it's just a gap in the rules there. Okay. Then a ruling of the then there was this issue about dignity and people being treated with dignity, which is a good thing. But then it sounds like it's only the chairperson's decision as to what is dignified or not. We're not comfortable with that.
You don't like that?
No.
Oh, okay.
So we think that there should be some mechanism by which that can be tested. In other words, it should not just be the subjective view of one person, however powerful that person might be. But
isn't that about chairperson making a ruling?
Yes.
Which happens anyway as a presiding.
Yes.
So you don't want the chairperson to make a ruling?
No. Chairperson,
understand me.
Don't ridicule the point I'm making.
Okay.
Yeah, please. I'm saying, I know about I've been chairperson of many things, I'm sure, as you know. Yeah. So when you are a chairperson, you can make a ruling, but the question is whether that ruling must be godlike and unchallengeable. Are we together? Yeah. So that's the point I'm making. And what we had proposed, which my learned friends raised a serious concern about, a legitimate one, by the way. We said that a ruling of the chairperson in this regard with reasons shall be final unless it is successfully challenged in another forum. And we have abandoned that last part of the wording because the evidence leaders correctly pointed out that that forum, if it's an internal forum in Parliament, it might be easy. But if it's like a court or whatever, then it means we'll never finish here. Because every time you make a ruling, Honorable Chair, we would then have to go up to the Constitutional Court. Yeah. No, that's not what we had in mind. I just want to put it out there. We simply, and we're leaving it again in your hands, want a mechanism, whatever it is, that might be deadlock breaking if we don't agree with your ruling. That's all. It's quite simple. Okay, now this one might be important. We said the evidence, what is the body of evidence? We were suggesting that only if evidence has been directly referred to during the hearing, should it form the body of evidence. By that, again, without being legalistic, we just mean what will be the record? Let's assume there's some court proceedings or whatever. What will we call the record of these proceedings? Will it be the 11,000 pages, I think by now, of documents? Mm-hmm. Or will it be the documents that would have been referred to? And again, in court, that's quite a simple. In fact, in court, you don't even have to say this. In court, you have what you call a bundle. Mm. So the plaintiff has a bundle, the defendant has a bundle, or sometimes we have something called a joint bundle. But the documents that will make it, so to speak, into the record will be those where witnesses have testified about. The rest, if you put all sorts of letters, they just fall away. Yeah. So that's really the kind of thing to simplify. We were alluding to there. Yes, then there's a proposal from the other side to us, which we have not yet considered fully. So while we are considering these other issues, we'll also consider this. They put a clause 6.2, no person, whether evidence leader, member, public, while questioning witness shall impugn the character of that witness unless he or she has a reasonable grounds for doing so. The character of the witness is relevant to the evidence, that's normal. And evidence supporting the claim against the character of the witness has been filed with the secretary of the committee at least 3 days prior to when the witness has been scheduled to give evidence. Let me hasten to say the principle is trite, but is whether you need this cumbersome thing about putting things 3 days before and so on. So I think that's something we can maybe find a formulation that makes us all happy, but we're raising it here. Yeah. Thank you, Chair. Unless if I've left anything out, Ms. Bauer, SC will correct me, but those were the issues that we identified, and we would like the committee to consider the technical issues. But for my part, I would like you to consider the substantive legal issues, particularly the ambit and scope of this gathering. Thank you very much.
Thank you very much, Advocate Mpofu, for tabling all of those issues. I see the hand, maybe before I recognize you, just an apology. I had extended this without any break. I didn't want to break the presentation. It's not that I disregard your own health. I wanted to propose that perhaps we break for lunch now, we come back, and then we raise those issues, given the fact that we would not have had a break. And I will recognize your hand, Honorable Mulder, Honorable Milham, Honorable Hendricks, and Honorable Ngola, in that order. The time now is just 6 minutes after 1. Should be back at 2 o'clock from lunch, and then we resume and take from where Advocate Mpofu left. Is it okay with everybody? And in virtual, you can wait for us until we come back. We don't have a virtual lunch. Thank you. The session is adjourned until 2 o'clock. Thank you, colleagues and members.
Recording stopped.